Welcome today to the Children First Family Law Podcast. I am so grateful today to have with us Justice Tom Altobelli, hailing to us all the way from Sydney, Australia, where I believe it is early morning there. Is that correct? Welcome.
That's right. Yes. Thank you. Great to be with you, Krista. Thank you for the opportunity.
Thank you. Looks like we got our time zones right. We were worried that we would somehow mess this up. So I'm glad it's not the middle of the night there. So I am so honored to have Justice Altobelli with us. He has been on the scene in the United States and internationally, I think it's fair to say, in the Association of Family and Conciliation Courts. So has a lot to share about what's going on in various countries, and especially comparing Australia to the United States and how we handle family law in both places. And also has been on the bench handling, you said, I think 5 years exclusively family law and 14 before that in the Sydney area doing family law. Is that correct?
Correct. Yep.
Wonderful. Well, first, I think we should maybe just start with a small disclaimer, correct? That he is appearing here in an individual capacity with a lot of knowledge of his work down in Australia, but not giving any sort of sense of how he might rule if litigants came before him. Is that correct, Your Honor?
Absolutely. The context is education, professional education. And I'm just sharing from my experience and certainly not suggesting what might happen if a particular case came to court before me or anyone else for that matter.
Absolutely. Well, tell us a little bit, Judge, first. Did you work as an attorney? What's the path to becoming a judge?
Yeah. So I was both an attorney and for the 10 years before my appointment as a judge, a family law professor at a university in Sydney. That was in parallel to practice. So, as I say, it was 25 years in practice before I was appointed as a judge. Initially, that was as what we called back then a federal magistrate. That then became a federal circuit court judge. And just over 4 years ago, I became a justice of what was then the Family Court of Australia. It's called something else now, but that's what it is in substance.
Does Australia have separate family courts? Separated from, because the United States, like in Colorado, we do not. We have our judges are rotating constantly. We don't have a dedicated family court bench.
Yes, one of the big differences that I've noticed in all of my interaction with my fellow United States and North American judicial officers is that in Australia we have a specialised family court. It has been since 1975. The other big difference is that family law in Australia is largely federal law, whereas in the United States, correct me if I'm wrong, Krista, but each state seems to have its own family law, either in one statute or in several statutes.
That's correct. We have some uniform statutes that have been adopted, for example, parental kidnapping. And there's some uniform code, but it still has to be adopted in through each state. How long do cases take generally in Australia?
Yeah, tough question. The cases take too long.
Maybe start answering that by walking through that process, because you have some things that we don't see in North America as frequently. So go ahead and maybe go back to what you were told before about the compulsory mediation, the various things that you have to try to get under. You talked about family
relationship centers.
Relationship centers. Tell us about.
Well, let's go back to 2006. 2006 is the year that I came to the bench. In 2006, we had some major amendments to the Family Law Act that introduced the concept of shared care. We've now changed that. But at the same time, in 2006, we had compulsory pre-filing dispute resolution. We had reportable therapeutic interventions provided by the court, and we had the establishment of what was called family relationship centres right across Australia. The whole concept of the Family Relationship Centre, or the FRC, was that it was the first stop for separating couples. In fact, it was the first stop for any relationship that was in difficulty. There you could get counselling, you could get mediation, you could get referral to specialist services, you could just get information about the process of separation and the impact on children. All of this was government funding. All of this was meant to be highly accessible to everyone. It was low cost or no cost, depending on the financial circumstances of the parties. Before anybody could actually come to court, they would have to get a certificate that was signed by a family dispute resolution provider that certified that they had not just attempted settlement, but they had done so in good faith. So back in 2006, we see an enormous investment of resources by our federal government. The aim of which was to try to keep people out of court, to encourage them to settle without coming to court, and to just lower conflict. I think the government was hoping to possibly, reduce the number of families and relationships that were actually breaking down. I don't think that happened, but it made the experience of people starting that process much, much more positive. And I know that in all the children's cases, there was this unequivocal focus on what's best for the kids. What's best for the kids? How can we navigate this incredible change in our lives whilst doing the least damage to them? Now, the interesting thing is that, I'm talking about compulsory pre-filing dispute resolution. Krista, I suspect you have a deep interest in dispute resolution as I have, and I started mediating relatively early in Australia. I was one of the very early lawyer mediators. I think I did my first mediation in 1990, something like that, which for us was pretty early on in the piece. At a time when a lawyer doing mediation was regarded with deep suspicion, but that's changed enormously. Enormously. So the importance of mediation has grown over time. Back in the 90s, there was a vibrant debate here, and I suspect in North America and in other parts of the world, about how you could possibly make mediation mandatory. Now, we've worked through that. We don't make settlement mandatory, but gee, we make attempting to settle, participating in a process and doing it in good faith mandatory. And even once you come to court, if you think that's the end of trying to settle things, well, you are sorely mistaken. You're going to be disappointed, because at every stage in the litigation pathway, from the time you commence proceedings in a family court in Australia to the time that you come before me, and Krista, I'm the end of the line. I see, that probably 4 or 5%, because our system has facilitated the other 95% of people who commence proceedings, has facilitated settlement, because that's the focus: empowering, encouraging, educating parents to settle cases about their children with assistance that's provided by highly trained in-house court lawyers. We call them registrars, and counsellors. We call them court child experts. And I think it's a real testament to the system that we have, that, somebody like me, right at the end of the line, so to speak, is only seeing 4, maybe 5% of those cases. And when they start the case before me, what do you think's going to happen, Krista?
Yeah.
I'm going to talk to the parents and just remind them about what is going to happen, how this is going to affect them, how it's going to affect their children, and how even now it is not too late to take back control of this conflict. I tell them, listen, you're the expert about your children. I may well have the responsibility to make a decision, and I'll do that drawing on all my experience, I assure you, but I'm still not the expert when it comes to your children. You are. So the focus on settlement starts before you enter the court system and doesn't stop even on that first day of the final hearing when somebody has to make a decision for you.